Jennifer Bryan, our Kelsey expert and rugby badass, Kim Repecka, and they're going to present Paternity. Woo.
Hi everybody, I'm Brooke, if you don't know me, so we're just going to talk about paternity for a little bit. Okay. So of course, as you know, the law recognizes 3 categories of fathers: alleged, biological, presumed, and then Kelsey S is kind of its own weird category. So a man that may be the father of a child but who has not established his biological paternity or achieved presumed is alleged. And I have a question for a Starbucks card if anyone wants to answer it. So alleged fathers are entitled to two main things in a dependency case. Does anyone want to tell me what they are? The 2 things that alleged fathers are entitled to?
Notice.
And?
The opportunity to try to become presumed.
Thanks.
Yeah.
So it's notice and an opportunity to ask to elevate to their status. So they aren't entitled to custody or reunification services, and they're also not parents within the meaning of WIC 317. So technically they're not entitled to a statutory right to counsel either. But the courts of appeal have found that they have a constitutional right to effective counsel, to assert notice issues, and request presumed status. Okay, so the key notice provision here is 316.2. So it states that at the detention hearing or as soon thereafter as is practicable, the court has to inquire of the mother and any other appropriate person as to the identity and address of any alleged fathers. So the court has to make the inquiries that are on the questionnaire we have the moms fill out. 316.2b says that the alleged father who is identified shall be provided notice at his last known address by certified mail return receipt requested. And the notice has to state that he is or could be the father of someone who is the subject of a WIC 300 proceeding and that he could be TPR'd as a result. The notice also has to include the JV 505. And as we know, it's important because it allows them to make the request to elevate their status and explains their rights. So if a man appears and requests a judgment of parentage, that finding has to be made as well. We also have California Rules of Court 5.635, which states that the clerk has to provide the alleged father with a copy of the petition, notice of the next hearing, and the JV 505. The rule also states that the court has a duty to inquire about and attempt to determine paternity. The court has to see, is there a prior judgment of paternity or a voluntary declaration, and if not, the court has to make appropriate steps to make such a determination. So we'll get the JV 505, the court may order genetic testing, or consider the statements of the alleged parents, of course. Okay. So this case is in Paul H. In this case, the court reversed an order terminating parental rights because the court failed to comply with 316.2. The alleged father in this case appeared right after he first talked to a social worker. He said, I might be the dad, but the court decided they were going to move right along anyway, sustained the petition, denied FR, and ultimately TPR'd on this guy without ever making a paternity finding and ensuring that he got a JV 505. This guy asked multiple times to get a DNA test. He was shot down by 4 different government offices, including the social workers. He even submitted a big packet of documents of the efforts he made to get a DNA test, which the court graciously accepted after terminating his parental rights. But the Court of Appeal found that he was prejudiced by the court's failure to follow 316.2 in the rules of court. The court said this guy could have gotten FR if he was given the chance to establish paternity, and there was no evidence to say that he wouldn't have. So the matter was remanded. Next we have Cody A, which is not a good case for alleged dads. The Court of Appeal found that the trial court screwed up notice under 316.2 in the rule of court, but that the error was harmless, and the TPR was affirmed. This guy was incarcerated from 2 days after the child's birth until the last few months before he was TPR'd. The father got notice, but it wasn't certified mail return receipt requested. He didn't get a copy of the petition or the JV 505. and he wasn't notified that he could be TPR'd until at the 2-6. Unfortunately for this guy, he waived his right to appear in court and checked the box saying that he wanted his attorney to proceed on his behalf, but that attorney didn't exist until the 2-6. But unlike Paul H., the court had tons of evidence to hang this guy with. He could never have achieved presumed father status because he was incarcerated pretty much the kid's entire life. He made no effort to maintain a relationship. And the court felt pretty confident he wouldn't have gotten FR even if he had been properly noticed. He had a violent felony and been incarcerated beyond the 18-month period. So he hadn't been provided notice, but things wouldn't have changed, so the TPR was affirmed. Same situation, Isabella M. So if you're wondering why you should care about this, we have a good old ineffective assistance of counsel case in Re OS. In this case, as I mentioned earlier, the court found that this guy had a constitutional right to effective counsel and that right had been violated. The court vacated the order terminating parental rights and ordered a new dispo with new counsel. In this case, the court found that mother was floridly psychotic and the child was detained shortly after birth because she was crazy. And mom identified dad, but no further inquiries were ever made. Dad had been seeing mom while she was pregnant every day, but then she just kind of bailed and disappeared. Agency didn't try to find this guy. He only appeared when he asked a jail worker, can you help me find my baby? And he got in touch with the social workers that way. So he had visits, they went well, and he got visits at the next hearing, which was the 2-6. And counsel did absolutely nothing for 3 months. The attorney actually acknowledged getting multiple calls from this guy, but said, I figured I'd talk to him at court, and then that didn't work out because she wasn't there at the next hearing anyway. Someone stood in for her and it requested a continuance in DNA testing, but that request was denied. He got TPR. So the Court of Appeal noted that the court didn't make those inquiries under 316.2 about paternity, but the important part is that the trial attorney didn't raise these issues and didn't ask to elevate his status, and the father was prejudiced as a result. There was no evidence that he wouldn't have received services otherwise. And you can see from the quote there, it says that a reasonably competent attorney knows that notice to alleged father is critical because it allows him to appear and assert a position. Also, it says that a man's status is presumed or bio is critical to whether he has rights. So an attorney handling a dependency matter needs to be aware of these issues and take appropriate steps. So we all got to do that. Also, just a little bit more notice, under WIC 291 and 294, alleged dads are entitled to notice for adjudication and for a 2-6, but they're not entitled to notice for review hearings because only people getting services are entitled. Sometimes we argue that a court shouldn't sustain a petition against an alleged father because he has no right to custody. So the Court of Appeal in a recent case in HR said that the petition can be sustained. Oops, sorry. A petition can be sustained against a parent who's just alleged. Oh, sorry. Because it's always a possibility that he could elevate his paternity status. The court said the way to get out of this, if you really wanted to, was to check the box in the JB 505 saying, I'm not interested in this case, I don't want to participate. But that doesn't mean we all shouldn't argue nexus anyway. You argue that if your client hasn't been a part of this child's life, how could his behavior have had a nexus on the child? So there's that still. Okay, so standing to appeal. If an alleged father doesn't appear in the court in the trial court and attempt to elevate his status, he's technically not a party and doesn't get to appeal. But if an alleged father appears and asserts a position in the trial court, he does have standing on appeal to raise issues about his parental interests, basically notice and the paternity determination. So that's what he can appeal about. Okay. Now we'll move to biological fathers for a bit. So a biological father who has established paternity but hasn't achieved presumed is still alleged, but he gets the additional opportunity for reunification services if the court determines that they will benefit the child. And when we're talking about establishing paternity, that means blood testing or based on testimony, declaration, statements of the mother and alleged father. Obviously, our goal is to get presumed. That's what we want. And biology is not enough to get us here, as you can see from the quotes on the slide. We need an existing relationship. So let's talk about how to achieve biofather status. It's governed, the genetic testing is the first way to get there, and that's governed by Family Code 7550 to 58. 7551 says that in a proceeding where paternity is a relevant fact, the court shall order DNA testing if the party makes a motion at a time not to delay the proceedings, and the court can also order its own testing. Also, we have 5.635H, which says that if a person appears in a dependency proceeding or requests a judgment of parentage on the JB 505, the court has to determine whether he's biological and has to determine whether he's presumed, if that's the finding that's requested. Okay. Baby Boy V said that the court has to make this determination. It's mandatory. They can't just say, or just can't say, I don't feel like dealing with paternity. So in this case, the mom had refused to give father's name to the court or to DCFS. 8 months later, mother told the father, Jesus, about the baby. Father contacted DCFS, came to court, again requested DNA multiple times, but Judge Spear wanted to just steamroll toward adoption. She refused to even address paternity because Jesus might not be the father. She even called him Casper the Friendly Ghost for some weird reason, and said, based on absolutely no evidence, she didn't think he was the father, which statement of the Court of Appeal found particularly interesting. The Court of Appeal basically made a fool of Spear, saying she should have addressed paternity. So I'll say, aw. She should have ordered a DNA test. She screwed up. Okay. Henry BC is another good case for biofathers if you're trying to get a DNA test. This guy had an 11-year-old kid, had zero relationship with him, but as soon as he found out about the case, he showed up, requested DNA. The court authorized the DNA test, but ordered him to pay for it. The Court of Appeal said, nope, trial court's failing to make a determination of paternity by making him responsible for the DNA. The court reversed the TPR, said the court has to make the determination. It said pretty much the only way to do that here is by DNA, but there are other options too. The court in that case also disagreed with Joshua R., which is another interesting case on the issue. The court said that you have to determine biological paternity under 5.635 even if the father might not qualify for presumed, and you don't have to show that making the paternity determination would benefit the child. It's mandatory. And they said in this case the guy didn't sleep on his rights, he came forward right away. Joshua R., I'm just going to mention it briefly because it has a different take on this analysis. In this case, there were 300 petitions on this kid. In the second petition, the kid was 17 months old. Joshua Sr. signed a form saying, I'm not the dad. And then a few months later, he changed his mind, sent letters saying, I'm sorry, I want to be involved, blah, blah, blah. But never actually appeared in court until the kid was 5 at the third petition. In the interim, he didn't ask about the child, didn't try to get visits, didn't try to get custody, didn't really care at all. So the court said, I'm not going to order a DNA test now, it's not relevant, and it's kind of like too little too late. So the court said, I'm not going to order a DNA test, and it was affirmed. So if there's conclusive evidence establishing that a father is not biological, of course you don't have to order a DNA test. In INRI DP, the child was conceived late August 2012, but dad had been incarcerated since early July, and he never met the kid. So the court said, you're not bio, you're not presumed, you're not ordering a DNA test. Okay, so if we don't have a DNA test, we're just looking at the other evidence, statements of the mother and the alleged father. You can still get that biological paternity finding, and you should request it, even if we don't have DNA test results. In HR, Zeidler found this father of a 4-year-old to be alleged not bio. Court of Appeal upheld. The mother said, oh, this is the only person that can be bio. He's definitely the bio dad. She testified about this. Dad also said at trial, I'm definitely the biological father. But In the years prior, Dad kept saying, I'm not sure. He was vacillating, he had no relationship with the child. And Grandma was saying Mom was sleeping around. So they said, not enough here, only alleged. But if you have a little more, better evidence than that, a guy that's not denying biological paternity, you can still get that biological finding, which will get you reunification services. Okay, so just the key points so far from my part is that if you pick up an alleged dad, especially if it's post-dispo, you have to right away check to see if he was noticed under 316.2 and Rule 5.635. Certified mail request, certified mail return receipt requested, the JV 505, and a warning that he could lose his parental rights. And you can put that in your Ainsley motion. Be sure to make requests to elevate his paternity status, and the JV 505 is key. Some courts don't require it, but it's good for your record. Also, make sure that if you're submitting that JV 505, that the court's actually making a finding and not deferring it and saying, I'm going to wait for whatever. Push the court to make a finding. And if you need help getting the court to order a DNA test, go with Baby Boy B or NRA BC. Okay, so biological fathers are not considered parents, according to the Supreme Court, under the Uniform Parentage Act. So the Supreme Court found that they're not entitled to custody under 361.2. The court said that if we say a parent is a mere bio parent, that could include people that have never shown a commitment to the child, would cause services to be granted to a rapist or an anonymous sperm donor. Father in a different case, one of, again, Zeidler's cases, NRA ET, tried to get around this rule by saying, I'm a relative under 361.3. The court said, no, you're not. So that didn't work. What you can try to do is get the court to grant overnights or an extended visit with your client so that they can qualify under 7611D, elevate to presumed, and then they could get custody. Or you get the parents to execute a voluntary declaration of paternity, which Jennifer will talk about in a bit. They're also not guaranteed reunification services. The court can order services if it finds that it would benefit the child. And what the court's going to look at here is what efforts is dad making to be involved in the child's life. All right, that's alleged. And just briefly, we have to consider the timelines when it comes to biological fathers requesting FR2. If the guy's showing up after the FR period is over, requesting reunification services, he has to file a 388 and make the requisite showing. All right, I'll pass it off to Jennifer.
So, a presumed father defined is a man that has promptly come forward and demonstrated a full commitment to his parental responsibilities, which include emotional, financial, and otherwise. NRA Jerry P is my new favorite case, so I'll be discussing that a little bit more in detail in a second. Only mothers and presumed fathers are entitled to family reunification services and are afforded all rights to parents' independency proceedings, including appointment of counsel and FR. So under Family Code 7540, the child of a wife cohabitating with her husband who is not impotent or sterile is conclusively presumed to be a child of the marriage. We do see that once in a while. And then we deal primarily, at least my experiences, deal with primarily presumed parents under 7611D, which is a man is presumed to be a parent, a father, if they meet any of the conditions in 7611. There are multiple ways a parent or a father could be found presumed under this code, except that we deal primarily with D. So A, very briefly, is a parent and a mother who have been married, and the child is born during the marriage or within 300 days after the marriage if the marriage is terminated, or if they've attempted to marry, although invalid, and either of the following is true. The attempted marriage could be declared invalid by a court, and the child is born during the attempted marriage or within 300 days after the termination. Or if the attempted marriage is invalid without a court order, and the child is born within 300 days after the termination of cohabitation. So see, presumed parent, mother had married or attempted to marry. In partial compliance, although the marriage is or could be declared invalid, either the following is true. With his or her consent, the presumed parent is named on the child's birth certificate, or the presumed parent is obligated to support the child under a written voluntary promise or court order. Now, the one we deal with the most, obviously, is D, which the parent receives the child into the home and openly holds out the child as his natural child. Under statute, and I wasn't able to find any case law on it, but there is no required amount of time that the parent has to live with the child. So, not a day, not 6 months. I have had to make that argument to my court. The child was living with the parent for 2 days, and I asked for a presumed parent finding. Before that, he wasn't on the birth certificate, and he had never lived with the child before. The court declined or denied my request for presumed status, still released the child to the father, and then later I got presumed. So that's what happens sometimes. So when there's conflicting presumptions under the family code, Family Code 7611, under Family Code 7611, the conflicts are weighed. The one that should be chosen is founded on weightier consideration of policy and logic. 7612. Now, while biology is a factor to be considered, it is not a determining factor. Additional factors include someone else is stepping forward and asserting parental rights and the length and nature of any such adult-child relationship. I think it's important to note that recently a great deal of emphasis has been placed on the relationship between the parent and the child.
Hang on a second.
So,
give me one moment. Sorry, guys. Had a small glitch in place. I had to correct it. No, I'm having problems out in Lancaster. They're back up. There we go. They should be back up now. Okay, sorry guys, apologize.
San Diego's not up.
I see them on here. You may have to rejoin. Where's the, can't find the mouse.
I'm sorry, Jennifer, you could
continue? Okay.
Yeah, I see them on here. I see them here, so I don't know what to say.
Okay, she's gonna keep going.
Under Family Code 7612C, in an appropriate action, a court may find that more than two parents with the claim of parentage are parents if the court finds that recognizing only the two parents would be detrimental to the child. So in determining whether detriment to the child exists, the court should consider all relevant factors, including but not limited to the harm of removing the child from a stable placement with the parent who has fulfilled the child's physical needs and the child's psychological needs, and who has assumed the role for a substantial period of time. And a finding of detriment to the child does not require a finding of unfitness of any of the parents or persons who are claiming parentage. 7612C is intended to be reserved for rare cases where a child has truly more than two parents. So a relationship, so rather finding that there's an existing relationship and not recognizing a potential for additional parents. So non-biological fathers can be found presumed parents. And this kind of where I bring in the case in Ray Jerry P., which is a great case, especially when we're dealing with what we see often is positive talk babies that are detained from birth. So this is a case that the father dated mom for about a year before the child's birth. He assumed that he was the biological father, had told everyone that mother was pregnant with his child. He eventually left the mom when she was pregnant because she wouldn't stop using drugs. But he did continue to provide support for the mother while she was pregnant, even provided her with vitamin supplements and bus fare to the doctors. Mom goes into labor. He goes to the hospital, but it's silent. The case is silent on whether or not he signed the voluntary declaration, and I'm assuming that he did not. But he identifies himself to the hospital staff as the father and is allowed to hold and visit with the child, Jerry. Jerry and Mom both test positive for cocaine at birth, and Jerry was detained from the hospital. Father was told by the hospital staff that Jerry had went home with the mother's family. Father went on to search for Jerry and was unaware that Jerry was placed in foster care until 4 months later, when DCFS advised the father of the 2-6 hearing, because of course mother lost other children in the system, so she was bypassed family reunification services. So dad shows up to the 2-6 and was appointed counsel and requested a DNA test. The 2-6 was continued multiple times. The father's counsel had filed 388 seeking presumed father status. But FYI, of course, the DNA test comes back and he's not the biological father. But it does nothing to stop him from wanting to be the child's father. So the 388 was heard, and the evidence before the court was that father visited consistently, called the foster mother 2 times a week to check on his well-being, brought diapers, food, clothes to the visits. The foster mother even testified on the father's behalf that the father would buy Jerry something every minute if he was allowed to, and that the father was extremely dedicated to the child. The social worker also acknowledges the child is comfortable with the father, and then there's evidence that the child's face lit up when he saw the father at the beginning of the visit and cried when he leaves, and even calls him daddy. However, the department, I'm sure wanting to reach permanency through adoption, was not in agreement with the father receiving family reunification services or with the presumed father finding. So they filed for a rehearing once the trial court had granted presumed father status for the father and his 388 for family reunification services. So the rehearing was granted. The court then finds that he did not meet presumed father status because he never took the child into his home, and they didn't grant him family reunification services. So father files a timely notice of appeal on that denial. And the the Court of Appeal disagreed and said that 7611D is 2-pronged, holding out and receiving the child into his home. And here, as to the first prong, the court said the evidence in this case leaves no doubt that father established a father-son relationship with Jerry before his birth, and that this relationship continued through the hearing on JR's presumed father status. So without question, Jerry promptly came forward and demonstrated a full commitment to Jerry's welfare, emotional, financial, and otherwise. So I'm sorry, Jerry's obviously the child. So the second prong, the court said that the father was thwarted by mother and third parties in an attempt to satisfy the requirement of taking the child into the home, which I think is the most important part of this holding. They go on to state, like Kelsey S., the facts of the case demonstrate a man who has established a loving and nurturing parental relationship with the child cannot be denied presumed father status because through no fault of his own, he cannot physically bring the child into his home because of the mother or DCFS has not made it possible. That this would violate the federal constitution guarantees of equal protection and due process to the extent they allow a mother or a third party to unilaterally preclude a father from demonstrating his full commitment to his parental responsibility. So the order denying father family reunification services was reversed and remanded. But for us, I think that's really important. We do have a positive toxicology baby, and fathers always deny the opportunity to take the child into his home, just to understand that that can't be a basis for denying presumed father status.
So if I can jump in on this side for just a second. One thing to be aware of also is that while a non-biological person can be a presumed father, there is case law that you might be arguing either as mother's counsel or you might just want to be aware of that DCFS or Minors Council could use. And in Re TR 132 Cal App 4th 1202 does say that if the father has acted in a way that is completely contrary to a parental role, he doesn't get presumed status just because he kind of acted like he was dad or was stepdad before that. So that was a sex abuse case. It's a registered sex offender who was convicted of sex abuse previously, and then they brought sex abuse allegations that were similar about his stepchild. So they were pretty sure he had sexually abused the child, and were saying, no, you don't get 7611D status when you're the non-biological father. That's insane.
And then to jump, and I have had mothers.
You're skipping.
I know. Should I know? Should I go straight to B? So do you want to talk about process? Okay. So Kim is going to go back.
We thought we were just gonna skip her part entirely. That'd be better.
Yeah. You can read
You don't want
LCS
to
on
know.
your own. It's fine.
Kim's talking now.
Okay. I did already step on your part. That's fine. I have no idea whether or not I'm in frame here. It's fine. It's dead. Okay. For Starbucks card, whose cooperation would Dad need in order to be found presumed under all the criteria that Jen just laid out for us? Receiving the child into his home, signing a birth certificate, marrying mom. Well, we're all going to answer at once then.
I answered first.
Did you? I mean, sure, coddles, why not? So the language for Kelsey S. is that this is a biological father. So that's interesting since Jerry P. involved a non-biological father, but Kelsey S. specifically says a biological father who has promptly stepped forward and demonstrated a full commitment to parental responsibilities, but who has been thwarted or prevented. And that language very much mirrors our 7611D language, except that we have the extra element of has been prevented. That doesn't need to be mom, it can be someone else, and in fact, in some cases, it has been the social worker, as noted in there in Andrew L., and in another case, Julia U. This is one of our earliest cases that tells us that Kelsey S. applies to dependency hearings. In this case, we had a minor mom. I'm blocking this, aren't I? We have a minor mom who offers up a first person that she thinks this is the daddy. He's incarcerated, he's an adult, he denies paternity, and then bravely takes a DNA test anyway, which also finds that he's not the father. She offers up two more names, another incarcerated adult who also denies paternity, and a third person who is also a minor. And they have a little bit of a hard time finding him at first. She gives them some information to find this guy, his city that he's residing in, and his mother's name. And DCFS, in fact, does notify his mother, and his mother says something along the lines of, we're not sure if he wants to be involved or not. But they never talk to him directly until several months later. And when they talk to him several months later, he says, well, if that's my daughter, then yeah, I want her. I want custody of her. Provides a written statement, it's filed with the court, that says, if Julia is mine, I want Julia. County comes back and says, well, he kind of sat on his rights. He took like several months to do this DNA test. Of course, he was 17 and he needed his parental consent to do the DNA test, and they sort of didn't notify him and sort of didn't tell him to show up to court. They just said, well, we'll get to that when we get to that. And then 6 months later, he's the biological father. So they waited several months on that, and basically the court turned around and said, no, we're not going to blame him for that. And one of the things that they relied on in large part was that the minor mother had named 3 potential fathers. Basically said he couldn't be blamed based on Trisha's promiscuity and the appellant's casual relationship with her. The evidence is weak that he had reason to expect his sexual activity with Trisha would result in her pregnancy. As we know, having sex with a person once does not result in a baby. So that was important. Baby would be. So Brooke already talked about this a little bit, and I have a little bit of an asterisk next to qualified under Kelsey S. And the reason for that is that technically the Court of Appeal did remand this for a rehearing on that specific issue. However, they did say, quote, father was non-offending, stable, employed, financially responsible adult who came forward at the earliest possible moment. They seem to be sort of giving a directive to the trial court that we think he qualifies. You probably should say that he qualifies. And this is where they really lambasted the trial court Judge Spear for the various statements that she made about how he's not the father, doesn't have standing, and at one point sort of bullied the minors council into saying, why are you supporting a DNA test? Why don't we just go forward today? If you terminate parental rights, quote, that's the end of him. I mean, what are you going to do? Like move this kid into this guy's home when he's in a pre-adoptive home? What are you trying to do by doing that? I just don't see the point. There's a lot of really fun quotes in there. I recommend taking a look at it. It's hilarious. It's terrible. Now, In re Vincent M kind of cuts the other way, and they disregard what could be a reading of Baby Boy V as a Kelsey S case. They basically say, we think that's dicta. And we have a guy with some pretty similar facts, actually. He didn't find out that he was the biological father until late in the game. Mom named someone else. They did a DNA test. Not that guy. He was in New York at the time, was not notified until the 2-6 was already set. And in this case, the Court of Appeal actually said that the biological father seeking reunification services with the child who does not come forward in the dependency proceeding until after FR has ended must establish best interests under 388. And it doesn't matter if his paternity was concealed from him or not, and they relied heavily on Zachariah D. to make that decision. That's a little bit of a dark one. I don't like it. Elijah V. was not a Kelsey S. father, and this is also interesting because Jennifer made mention of how there is not any sort of limit on time that a child has to be received into a father's home. Now, in this case, the father actually didn't argue Kelsey S. He argued 7611D, and the court said he wasn't presumed. He had lived with the child as an infant for several weeks. And essentially, the court looked at it and said, no, you were like babysitting for mom in mom's home. You weren't living with the kid just because you were like establishing a residence there at the same time. Not the same thing. But there were some very, very bad facts in this case. For instance, the dad actually did a home DNA test, so he knew this was his kid. And the mom was married to someone else, and he just let that guy raise his kid and think it was his. The court seemed especially disturbed that the child had reached about age 8 or 9 at that point and literally had no idea who Armando, his biological father, was. And in fact, he moved out of state at one point during the child's life. He waived the Kelsey S. issue by not raising it in the first place, and it was not implied by his request for presumed status or FR services, according to the court. In re MC is a father that did qualify under Kelsey S., but actually had some similar facts. He moved out of state during the child's life, and he didn't assert his rights when the kid was born, or when mom was clearly trying to carve him out of the child's life. Instead, the court still found him to be a Kelsey S. father, and they relied on some financial support they gave the mother. Not much, a little bit, during pregnancy. And he ensured that she got prenatal care. Mother also lived with him and his family for a few months while pregnant. He made contact with his own mother to stay informed about the status of the child. And one of the things that I think the court was relying on heavily here was that mother misled DCFS and said she had no contact information for this guy. Had not spoken to him since the child was born, basically denied all these other facts that came out later. But the court believed him to be the most stable and capable parent that was available. Mom was using drugs, mom was having ongoing domestic violence with her, at the time, wife. And the court relied heavily on the factor that the father must come forward as fully as the mother will allow and the circumstances will permit. So it seems as though the thwarting aspect can sometimes get you off the hook on the coming forward fully aspect. And, quote, the law doesn't require him to do everything he possibly can. That's important because the court loves to put our clients on the stand and say, well, why didn't you do this? Why didn't you do that? What about all these things that you could have done that were available to you, and then fault them for that? But you don't actually need all of those factors. This case was sent back to the trial court for them to do the balancing test required in 7612B because we didn't have 7612C yet, saying that you could have more than 2 presumed parents. But the part of it that was published was clear that they did think this guy qualifies as a Kelsey S. father. Adoption of HR. This guy had some super bad facts. He had alleged domestic violence with the mother. She asked for a TRO. It was denied, so that matters. But the court basically said he was a Kelsey S. father and then found him unfit and terminated his parental rights. And this, amongst some of the other cases, does establish the rule that a trial court cannot TBR a Kelsey S. father without a determination of parental unfitness. So that's basically what you get from Kelsey S. You don't necessarily get custody. It's not clear that you're entitled to much of anything else, but they can't terminate your rights unless they find you to be unfit as a parent. And the way that you get that finding is from code sections 7820 and 7829 of the Family Code. Abandonment is one basis for that determination, and that's acting with the intent to abandon, not just that you haven't been around. And a felony that is indicative of parental unfitness. It is not entirely clear what that would be. The example they give in the case is that murder for sure counts. Grand theft auto and felony conviction for possession, probably not. Everything in between, a little less clear. You're supposed to look at the facts and the circumstances around the conviction, and the standard is clear and convincing evidence for that. This is another one that's sort of interesting because he seems like he maybe could have gone the other way. He does have some bad facts. He qualified as a Kelsey S. father. He had some reason to believe that he might be the father, even before the child's birth, namely that he slept with the mother. But the mother put another man on the birth certificate, let that guy believe he was the father, pay child support, and all of that. And that guy actually got presumed status when they first came to court, and fought like hell to keep it. And the trial court took it away from him and gave it to the biological father, who had requested DNA testing, took mother to a couple prenatal appointments, and was starting to say at this point, I want this child if this is my child. And the other father was the one who actually appealed it and argued, well, this guy only wants this child if it's actually his child. I know it's not my child, I'll still keep it. And the Court of Appeals said EA, that was the not biological father, cites no authority for the proposition that a Kelsey S. father must unconditionally assert his parental rights even before knowing whether the minor is his biological child, and we are aware of none. So that could potentially get you off the hook when your client is a little bit less sure of their paternity, when they haven't had a DNA test yet, and they haven't, for instance, provided financial support or other things like that that you would have hoped to see otherwise. Adoption of baby boy W. Oh, what a fun case. Okay, so they have this wonderful quote in here that's actually from a concurring and dissenting decision in a much worse case. And that case is Michael H. It's not very interesting. The dad in that case is just a dumpster fire of a human. He's like a 20-year-old that slept with a 15-year-old, then tried to marry her, and she said, no, I'm in high school and you're an alcoholic. And they decided to put the kid up for adoption, and then near the end he says, you know what, actually I don't think we should adopt out the kid, I want to keep the kid. And then in the intervening time there are domestic violence incidents. And they said, no, you don't get to block the adoption, you're not a Kelsey S. father at all. But they're quoting this here because the decision in that case, the majority decision basically said, if you vacillate about this adoption or no adoption thing, then you might have forfeited that right. And there was a concurring and dissenting decision that said, if the father tries to assert his right basically by contacting mom and saying, I don't agree to adoption, I don't want that, then is he at that point harassing her and making her unhappy in a way that's no longer emotionally supportive? So how do you weigh this and say, okay, he's trying to assert his rights and be very clear about what he wants without harassing her and making her very upset? And in this case, they said, no, he found that balance. He submitted something like 200 pages of text messages between the two of them, where he continuously says affectionate, loving things about how he loves her and supports her, but he doesn't support the decision to adopt out the child, and he's not going to. He has a home, he has a family, he has resources, he has support, he wants his baby. And he even started a change.org petition to try to change the status of the law in California. And that's the picture from it with his family. and their chihuahuas. And that's a picture of him on the left on his Facebook page now with his baby that he got as a result of that case. Isn't that cute?
He
White
was a
dads get
minor?
to keep their kids.
This one was a minor? Or-
That's the minor. That's the same minor, yeah. Yeah, really easy to find that information. Guys, put your Facebook profiles on private. Anyhow, this one went the other way. This guy did not strike the right balance in adoption of TK. So there are some good facts here. The parents planned to have the child together. They broke up right before mother learned that she was pregnant. They reconciled due to the pregnancy. Then they broke up and reconciled a bunch more times after that. But they established a baby fund, and dad put some money into it. And the mother started trying to adopt the child out. Father took a parenting class, he bought baby supplies, he established like a little nursery in his home. He made all these preparations to receive the child into his home. And then mom at some point said to him, well, I'm going to put the child up for adoption because we're separated, we're tumultuous, I don't want this for the child. And what he proceeded to do at that point was raid most of the money in the baby fund. He took most of it out. Left about $40. He borrowed more money from mom, like a few $1,000s. Then he cyberstalked mom and contacted her about how her prenatal appointments went, which she did not tell him about. So they were pretty sure he got that information from reading his email, or reading her email. And he also contacted all the prospective adoptive parents and told them, no, I'm not going to let you do this, and I'm going to interfere and like really make this difficult for you. And he falsified check registers that made it sound like he was giving more money to mom than he actually was. So if you have like a fraud that comes out during your case, then that's never going to go well. VDOPS. Take it away.
So the voluntary declaration is when a man signs at the hospital declaring that he is the father of the child. It needs to be, so it essentially establishes paternity of the child and has the same full force and effect as a judgment of paternity. The declaration contains a statement by the mother and the man signing that the man is the father and that the man acknowledges that he's the father and that there's no other possible biological fathers. The goal is essentially to increase the number of children who have access to support and decrease the time and money required to establish paternity. The VDOP's available at prenatal clinics, hospitals, local child support agencies, offices of local registrars of birth and death, the courts, and the county welfare departments. So these locations, staff is required to witness and execute the forms and to complete after the declaration is completed, to send it to the Department of Child Support Services within 20 days of the execution of it. So Family Code 7571F also allows social workers to witness the parent signing of the voluntary declaration of paternity and then to submit it to the Department of Child Support Services as well. So parents can also sign and have the forms notarized and then submit it by themselves to the Department of Child Support Services. There is no time limit on when a voluntary declaration of paternity can be signed. However, the appellate court, for our purposes, has found that a biological father asking for family reunification services after a voluntary declaration of paternity was filed with the state was insufficient. And basically they found that there was the 388's two prongs, as we all know, and that the father waiting 6 months to file the voluntary declaration of paternity when the child was under the age of 3, that ordering FR would have not been in the child's best interest, given the original period of family reunification services had already expired. And it would, of course, disrupt adoptive placement. So a voluntary declaration of paternity filed all right, so we'll leave that alone, and you have the signs in front of you. So voluntary declaration of paternity filed before December 31st of 1996 creates a presumption of paternity that can be rebutted. After one filed after January 1st of 1997 shall have the same force and effect as a judgment of paternity. So a voluntary declaration can be rescinded within 60 days unless a court order for custody, visitation, or child support has been ordered. And if the court finds based on genetic testing performed that a man who signed the voluntary declaration of paternity is not the father, that the court may set aside the voluntary declaration unless it finds that it would not be in the child's best interest. So where does a voluntary declaration of paternity get us in dependency proceedings? So the voluntary declaration of paternity entitles a man who signs it to presume father status in dependency proceedings. In re Liam Mel is the case that I always cite. However, there has been subsequent cases that do not make that finding. So in re EO, the court found, and this was based out of San Francisco, a father who signed the voluntary declaration of paternity but failed to show that he came within any of the categories of 7611D was not entitled to presumed status, and that paternity judgment alone does not entitle a father to presume father status. Now in that case, the children were 7 and 14 years old, had been sexually abused by the mother's male companion. They had no relationship with the father. The father had stated that he didn't have a relationship and never visited with the kids prior because he felt since he wasn't paying child support, he wasn't allowed to visit with the kids. So essentially no one wanted him to have presumed father status, including the kids. So they wanted nothing to do with him. So perhaps if the children were a little bit younger, things would have come out better for him. However, the court did go on to say that a paternity judgment is, as the name applies, a judicial determination that a parent-child relationship exists. It is designed primarily to settle questions of biology. Where they contrasted that with presumed father status, saying that whether a man has promptly come forward and demonstrated his full commitment to his parental responsibilities, emotional, financial, and otherwise. Now my $5 Starbucks question is, if a man has signed a voluntary declaration of paternity versus one that comes under the provisions of 7611D, which has better legal standing? Any guesses? Voluntary declaration of paternity or 7611D? What trumps what? Yep, and you're right. And that was a holding in Repecka Q, which was out of Orange County, that until the voluntary declaration is set aside, it has the same force and effect of a judgment. So it's not a mere presumption to be weighted against competing 7611D presumptions. So I have had our court clerk witness and file with the state the voluntary declaration of paternity. I do think it's important, and the family code that has it does state that court staff shall witness and then file with the Department of Child Support Services. Oftentimes mothers will agree to this, sometimes they won't if they're trying to thwart that presumed father status. Which again, it doesn't get you there, but it's a step closer. There is a rule of court that was enacted, I don't know where I am now, in 2015. It was amended. So California Rule of Court 5.635C states that if a voluntary declaration as described in Family Code 7570 has been filed and executed, that the man is entitled to be the father of the presumed father under 7611. So I think given the recent case law stating that it's not, this is just another good rule of court to point out when we're trying to get to presumed father status. So the declarations are important, but it's not necessarily, I don't think at this point, binds the court to find presumed. Any questions for any of us?
Yeah, why?
Why what?
I mean, a man is presumed to be the father under 7611 if the deed-up has been properly executed and filed. I
Well,
mean, what,
what I was told was that statutory interpretation of case law is gonna trump a rule of court. But I would still point to this, obviously, and I don't have a case that's after January 1st of 2015. Doesn't mean there's one out there. If anyone knows one, please share. I'll continue looking, but you know, yeah, I would automatically go through this. But the emphasis right now by the appellate court seems to be all about the relationship. So that's why if a parent comes forward like in Ray EO and the kids are older and they haven't done anything, I think that's a hard argument to make. I think if you're younger, if it's a positive tox baby or just a little baby, I think that's where Jerry P comes in handy, where they can't be thwarted by a third party or the mother from taking the child into the home. But I was asked earlier, you know, what we tell a client to get them to presume father status if they don't qualify yet, and my advice is to be a parent. So they have to act like a dad. They have to act like they want to be a dad. You know, I go to the dollar store all the time. There's bottles, there's onesies, you name it, you can get at the dollar store. So even though our clientele doesn't have a ton of money, you know, there's ways that they can show up at a visit with Gerber food snacks, with onesies, with bottles, with bibs. I think they even sell, you know, diapers at the dollar store at this point. So there's ways that they can do something. So when we have a positive toxicology baby, or you know, just a baby that's 3 months old at this point and mom hasn't let them see them or they're not quite sure, visitation and just providing for the baby, because in Ray Jerry Pete they did place a lot of emphasis on how this guy was always doing whatever he could to provide for the child. And in Ray Jerry Pete was also a case where the father didn't have the best of housing situations, which a lot of our clients don't have. He lived and worked at a shelter, and then was able to, that didn't accept kids, but then was able to get a shelter that would allow for him and the child to stay there. So again, he was somebody with very limited means, but he still did everything in his power to be a dad. So that's what our clients have to do, I think. It's just to really act like they want to be a parent. Any other questions?
Awesome.